Hey everyone, welcome back to the channel. We've got some incredible news to share with you today. And honestly, any day I get to bring you a Second Amendment victory is a great day. But what makes this even better is that this decision could have nationwide implications for waiting period laws across America. Yesterday, the 10th Circuit Court of Appeals dealt a massive blow to so-called cooling-off periods, and this is going to affect lawsuits in multiple states. Let's dive into this historic victory. Before we get started, make sure you hit that subscribe button and turn on notifications. Second Amendment news is coming fast right now, and you don't want to miss any of these developments. Thumbs up this video to help the algorithm spread this information, and drop a comment below with your thoughts. Every bit of engagement helps us reach more people who need to know about their rights. All right, let's talk about what just happened. As you all know, a right delayed is a right denied. Even if it's just for a few minutes, that's still a period of time where your constitutional rights are being kept from you. State waiting periods completely ignore this fundamental truth by forcing you to wait for extended periods, sometimes up to 10 days, supposedly to cool down. Think about how insulting that is. The government is treating every single person who wants to purchase a firearm as a potential criminal who needs time to reconsider. It doesn't matter if you have a spotless background, if you're a law-abiding citizen, if you've owned guns for decades. The state assumes you must be up to something nefarious and forces you to wait anyway. For those of us who actually understand the text of the Second Amendment, this is a clear violation. But for years, circuit courts have dismissed waiting periods as just a minor burden, not a real infringement. Well, that changed yesterday when we scored a major victory at the 10th Circuit regarding New Mexico's 7-day waiting period. The 10th Circuit basically said that New Mexico's cooling-off period likely violates the Second Amendment and refused to rehear a 3-judge panel victory from back in August. The case was denied en banc, meaning the full circuit declined to overturn the panel's decision. This is massive, not just for New Mexico, but for waiting period challenges across the country. Let me give you the background. Back in August, a 3-judge panel at the 10th Circuit, which is normally very hostile to Second Amendment rights, actually ruled in favor of the Constitution. They ruled that cooling-off periods violate the Second Amendment by preventing lawful acquisition of arms. They said these laws don't fit into any historic exceptions, meaning there's no relevant historical analog supporting them. The panel also pointed out that waiting periods impose a blanket burden across all of society without individualized determination. In other words, these laws treat everyone like a criminal, regardless of their actual background or circumstances. That's fundamentally incompatible with constitutional rights. After that 3-judge panel victory, most of us expected the state to request en banc review and for the full 10th Circuit to reverse the decision. The 10th Circuit pretty much mirrors the 9th Circuit when it comes to hostility toward gun rights. Up until this point, their likelihood of overturning a law based on Second Amendment violations has been essentially zero. But yesterday proved me wrong in the best possible way. The 10th Circuit denied rehearing en banc. Only 2 judges, Federico and Moritz, dissented from that denial. The rest of the circuit declined to overturn the panel's pro-Second Amendment decision. So, what happens now? The 10th Circuit has reversed the lower court's decision not to enjoin the law and remanded the case back down with instructions to enter an injunction on behalf of the plaintiff. Basically, the 10th Circuit has ordered the lower court to block enforcement of New Mexico's waiting period. When that injunction is entered, New Mexico's waiting period will be unenforceable. The law will technically still exist on the books, but no one can enforce it. The 7-day waiting period will be gone, done, finished. New Mexicans will be able to purchase firearms and take them home the same day, just like the Constitution intended. This is now binding 10th Circuit precedent. All other courts under the 10th Circuit's jurisdiction must follow this guidance. The 10th Circuit covers 6 states: Colorado, Kansas, New Mexico, Oklahoma, Utah, and Wyoming. Here's where it gets even more interesting. Colorado currently has a waiting period law, and there's an ongoing lawsuit challenging it. This 10th Circuit decision should dramatically help that lawsuit. The precedent is now clear. Waiting periods likely violate the Second Amendment. But the implications go far beyond the 10th Circuit. Right now, I believe there are approximately 12 states with some form of waiting period for firearms transfers. These include California with its 10-day wait, Hawaii with 10 days, Florida with 3 to 5 days, depending on circumstances, Rhode Island with 7 days, Illinois with various waiting periods, Minnesota, Maryland, Washington, Oregon, and others. All of these laws are now vulnerable to legal challenge based on this 10th Circuit precedent. While the 10th Circuit's decision isn't binding on other circuits, it's highly persuasive authority. Judges in other circuits will have to grapple with the 10th Circuit's reasoning and historical analysis. And here's the really exciting part. California has a case called Richards versus Bonta that challenges its 10-day waiting period. That case is currently working its way through the 9th Circuit. If the 9th Circuit upholds California's waiting period, while the 10th Circuit has struck down New Mexico's waiting period, that creates a circuit split. Circuit splits are incredibly important because they give the Supreme Court a compelling reason to grant certiorari and resolve the disagreement between circuits. And we already know where the majority of Supreme Court justices stand on Second Amendment issues. They've been clear in Heller, McDonald, and especially Bruen that the Second Amendment protects real rights, not theoretical ones. A Supreme Court ruling on waiting periods would affect the entire country. It would provide definitive guidance that all lower courts must follow. States couldn't play games anymore with cooling-off periods, mandatory delays, or any other scheme designed to burden the right to acquire firearms. The 10th Circuit's reasoning in this case is solid. They correctly applied the Bruen framework. Under Bruen, if conduct is covered by the plain text of the Second Amendment, the government must demonstrate that its regulation is consistent with the nation's historical tradition of firearm regulation. Acquiring firearms is clearly conduct protected by the Second Amendment. You can't exercise the right to keep and bear arms if you can't acquire arms in the first place, and there's no historical tradition of forcing people to wait arbitrary periods before taking possession of firearms they've lawfully purchased. During the founding era and throughout the 19th century, Americans could walk into a store, purchase a firearm, and walk out with it immediately. There were no background checks, no waiting periods, no paperwork beyond a simple sales receipt. The government had no role in the transaction beyond basic contract law.
A few historical regulations that existed dealt with specific dangerous individuals or specific sensitive locations. They weren't blanket prohibitions or delays applied to everyone, regardless of circumstances. That's the key distinction the 10th Circuit recognized. Modern waiting periods claim to prevent crimes of passion or impulsive violence, but the data doesn't support those claims. The vast majority of people who purchase firearms never commit any crimes, and criminals who intend to commit crimes don't follow waiting period laws anyway. They steal guns, buy them illegally, or simply wait out the period. All these laws actually do is burden law-abiding citizens. They force someone who might need a firearm for immediate protection to wait helplessly while facing a credible threat. They prevent competitive shooters from acquiring equipment they need for upcoming competitions. They make gun ownership more difficult for people who already face barriers due to poverty, disability, or geographic isolation. The 10th Circuit recognized all of this in their decision. They saw through the state's justifications and focused on the constitutional text and historical tradition. That's exactly what Bruen requires courts to do. This victory is particularly sweet because it came from the 10th Circuit, which hasn't been friendly to gun rights historically. If even hostile circuits are starting to correctly apply Bruen, that suggests the Supreme Court's message is finally getting through. We're seeing a shift in how courts approach Second Amendment cases. Between this waiting period victory, the recent open carry decision in Baird versus Bonta, the ongoing ammunition ban challenge in Rode versus Bonta with DOJ involvement in 25 states filing briefs, and the major cases on the Supreme Court's docket, the momentum is clearly building. Courts are finally starting to treat the Second Amendment like a real constitutional right, rather than a second-class privilege that states can regulate away. It's about time. I'll be following the Richards versus Bonta case in California closely. If that goes the wrong way and creates a circuit split, we'll cover the Supreme Court petition. If other states' waiting period laws get challenged based on this 10th Circuit precedent, we'll bring you those updates too. Make sure you're subscribed with notifications on so you don't miss any breaking news. Drop a comment below with your thoughts on this decision. Share this video with gun owners in states with waiting periods who need to know their rights might soon be restored. This is a major victory, and we should celebrate it while preparing for the next battles. The fight for our rights never ends, but days like this remind us that persistence pays off. Thanks for watching, and I'll see you in the next update.